we must take all the circumstances of this case. And the circumstances of this case then explain the paucity in the charge sheet as has been presented before.
We call for a short adjournment so the court is clear and the person has care.
There are some other rooms on the other side
that are bigger and more.
No, this is the biggest. Wampeleke the other
Your Honor, it is the last time we appeared in the court over this one. The court had to buy me microphone. I was avoiding that because I don't want it to go next. But it looks like, I mean, at a certain point, we may really need to think about fasting and whatever. But Your Honor, what I was saying is that the circumstances of the arrest and then demonstrate why. Yes, Your Honor. Yes, Your Honor. So my final point was that even though it might appear to be an overreach, but this court must look at the circumstances of the arrest, and it will be able to understand that the intention here is for this court to be a conveyor. We abducted him, we were unable to. So, Your Honor, what I was saying is that this court is intended to be a conveyor. We abduct or we arrest without any probable cause. We look for any reason and we present a charge sheet and place it before the court. And the court then is supposed to be the one to sanctify, because Your Honor, the moment you accept this charge, and I think if it was a proper charge, we would have no problem, even though we would have known it is communication. But the problem here is that, Your Honor, if you accept this charge sheet, especially as it is framed, then even this court will eventually almost be on trial the way our police are on trial. You know, for that reason, I'm noting that Mr. Morara had a young counsel that he had instructed. I'll ask that you allow Mr. Monka to just say one more thing And then I know all of us would want to say something. But I recognize that we also need to write ruling and listen. I'm being reminded it's also a
Please, Your Honor, my name is Marema. I humbly and wholly appreciate the recognition of my seniors, and I thank them for the knowledge that I've received in the past. However, there's one small thing that we haven't touched. Briefly, that's to do with the framing of charges under Section 134 of the CPC, Criminal Procedure Code, as read together with Section 135 of the Criminal Procedure Code, which dictates in mandatory terms that a charge must contain a statement of the specific offense in which the accused is charged, and enough information to demonstrate the nature of the offense. Much has been said about civil defamation. However, in brief, Your Honor, if you see count, it refers to cyber harassment under Section 27 of the Computer and Misuse of Cyber Crimes Act. However, when you read the particulars of the offense, specifically line 4, knowingly without lawful cause, knowingly without lawful excuse, posted false information. That is another offense under the Computer and Misuse of Cyber Crimes Act. Specifically Section 22 of the Computer and Misuse of Cyber Crimes Act. If you go on further, Your Honor, they repeated the statement, false, again. And then lastly finished with calculated to tarnish and discredit. Calculated to tarnish and discredit the reputation of one David Morara. So, Your Honor, in brief, the question is Morara answering to the charge of cyber harassment or to the charge of publishing false information or civil or defamation? Your Honor, in brief, as I associated both my learned senior Counsel Eric Thori stated, I was with Morara when he was being arrested. The police refused to grant me access to Article 49, and there are orders that have been given by the High Court that the police ought to respect and ought to follow Article 49 of the Constitution. Some of those orders I personally obtained them from the High Court. Additionally, they did not disclose why they were arresting him or who they were. Some of them were masked. Your Honor, the question is, we are dealing with people.
Sorry. All of us end up painting here. So please, just a request that you allow me to manage the crowd. I'm going to request everybody after the gentleman in the big camera. We're just going to ask you kindly to step out of the room. Otherwise, we can't face the Please, you can listen from outside. We have speakers. So now, if you have problems with that, we just have to wait. Because help comes first. Please. But I want to see you counsel speaking.
Oh, yes, yes, yeah. So,
Because you can get, so many of us are sweating. You can get the smell of sweat. That is really long term.
yes, Your Honor, I'll be brief. Your Honor, in
How many
brief,
more minutes will you take?
3-4 minutes.
Okay.
Your Honor, in brief, what we are witnessing here as a country is the weaponization of the criminal judicial process against a young man who, against all odds, stood up to speak the truth. And the truth has hurt many people who are currently in power. That truth has altered the status quo.
Sorry, you are not a witness. You are yet to take lead.
But in brief, Your Honor, history is being made, and I invite this honorable court to stand on the right side of history by quashing these charges and releasing the accused person on personal bond. He is a young person, he is a young person. To release, to free him from his charges. And lastly, as his personal lawyer, I want to thank him for actually believing in a young person. Fellow Gen Z, Your Honor. Fellow Gen Z. And we will stand with him together.
May the court afford exactly 1.5 minutes. My name is Achille Bradley. It's a privilege to appear before you, Your Honor, in this matter. And just to add to what has been said, the constitutional justification for the cause of action we are requesting you to take. If you look at Article 24, it is a balancing act that the court must strike. And the court must look at the least restrictive alternative. In this case, Your Honor, there is an alternative for the complainant. That alternative is called the Defamation Act. It's sufficient to address any reputational damages. And so there will be justice for the complainant, whichever, if you make the decision we are requesting you to make. And the other one is in Article 23A. That article obligates this court to adopt Article 20 Sabbatical 3A. You know, this court cannot interpret the Constitution. That jurisdiction belongs to the High Court. However, this court, as a constitutional organ, must apply the Constitution. And when you look at Article 23A, it requires this court and all tribunals to adopt the interpretation that most favors the enjoyment of rights. In this case, Morara's right to freedom of speech, especially on the issues he's speaking about. So, Your Honor, there's sufficient legal basis for you to find that this charge does not disclose a criminal case, and that the remedy, alternative remedy of defamation is sufficient. Thank you so much.
Your Honor, perhaps before the prosecution responds.
Just a minute, Mr.